What common misconceptions do people have about living trusts and how do you address them?
Okay, another great question. Before I go into the misconception, the number one misconception that I feel that most people have of a living trust, there's like three or four, and I'm going to give you like the top two or something. The biggest misconception is that a living trust needs to be done by an attorney because they don't understand what an actual living trust is. A living trust is a contract between you, which is the trustee, and your kids, which are the beneficiaries. So it means it's a contract that tells your kids exactly what you want to have happen when you're no longer here, when your number comes up. That the courts help enforce. So a living trust is a contract between you and your kids telling them what you want to have happen, and the courts help it enforce it in case somebody gets out of line, right? Because not everybody has kids that follow the instructions, or maybe they use the third party to be able to instruct it, and a living trust is. So that's the first misconception, is that you need an attorney. An attorney and a contract that the courts recognize has to have the legal provisions that each state, like for example, I just was on a podcast out of Canada, and they have estate planning as well. There's different provisions in every country, but every country has an estate plan. Every country wants to protect their citizens. So I want to go back just one step and say not only the misconception, but the first thing is to start off why does estate planning even exist? Most governments said we want to protect our citizens of the land. And how we protect them is to make sure that their land or their assets, because back when this law was created, it was created to protect because everybody had land, not many houses and apartments and flats and all these other things, or money in the bank, right? What they had was land. So they wanted to make sure that the land got transferred to the appropriate beneficiary. So they wanted to make sure it went to your kids. So then they said, well, you know what? You need to have a will. And then wills were only 2 pages long or 1 page long. I love you. I leave you everything. And then they started to create all of these different types of wills. And then they said, well, you know what? We need a stronger document that has more legal provisions and that there is no doubt without reason that you executed it. Then they created an estate plan that is now the difference between a will and a living trust in document is a will is 1 to 2 pages. If an attorney helps you draw it up, they charge you $500, maybe 3 pages. If a living trust, a comprehensive living trust, starts off at 150 pages. I have one trust, a gentleman had guns. He owned firearms. In California, we have firearms. He owned a business, he owned firearms, he owned a home, and he owned some collectibles. And he had a lot of instructions on his comprehensive living trust. And so what we did is we created a living trust for him, and it was like 270 pages that it came out to because it was on there. So the one biggest misconception is that it needs to be done by an attorney. One, it does. Two, second biggest misconception is that living trusts are not all created equal. Wow, right? Think about that. Living trusts are not created equal. Some have the very, very, very bare minimum of provisions, but they don't have all of the comprehensive living trust documents that you need to be able to have everything to secure your family and to secure your assets, which is the most important thing. And in case things happen, I'll give you an example. One of the biggest examples that we come up with on a comprehensive living trust is that it comes with a pour over will. A living trust has to have three things to make it a active living trust. One, it has to be signed in front of a notary. Two, it needs to be signed in front of two witnesses. Three, it needs to be funded. In other words, the assets need to be put into the living trust. That means if you own the home, you have to fund it to go into the living trust, or the living trust is not an active living trust. It's not going to protect any of the assets from the federal government. The third misconception of a living trust is that a will prevent probate. That means if I have a will, I got everything taken care of. It's okay as long as you don't meet the threshold. For example, in Colorado, if you own a piece of property and it's worth more than $60,000, then the government's going to get involved. So each state has a minimum requirement according to what's there. Those are the three biggest misconceptions. Are one, that a living trust has to be drawn up by an attorney. Two is that a will is enough. And three, I will avoid probate if I have a will. So those are the three biggest misconceptions of a living trust.